Well, the case of recaptured fugitive Thabo Bester and his co-accused continues to dominate the courts. Bester's partner in crime, this Nandipha Magudumana, wants her arrest and deportation declared unlawful. Her urgent application will be heard in Bloemfontein today, but our senior reporter ENC's Silindelo Masikane is there to keep an eye on proceedings, and she joins us now for the very latest. Lee, a very warm good morning to you. I see you bright and early this morning, colleague, already in the courts. Necessarily hasn't started yet, but a long morning just in terms of proceedings. What can we expect?
Certainly so. What we are expecting is just after 10 a.m. this morning. We are expecting that counsel for the respondents, as well as, of course, Dr. Nandipha, will be in this very courtroom to argue not only the urgency but perhaps the merits of Dr. Nandipha's application. Now, of course, we do know that she filed these urgent court papers last week, stating that she believes she was abducted by the South African Police Services in Tanzania and brought back to South Africa illegally, essentially, and she's asking the court to set aside her arrest as well as legal proceedings where she's accused of aiding and abetting Facebook rapist Thabo Bester. But to unpack and give us some analysis in terms of what we can expect, I am joined by legal expert Mr. Bartus Jacobs. Thank you so much for your time. For the layman who doesn't understand an urgent court application, let's start with what is required for somebody to file an urgent court application and whether this particular application meets those standards.
Thank you. Thank you for having me. Well, firstly, I think we need to, when we look at urgency and filing an urgent application, it is crucial that in your papers, in your founding affidavit, you ventilate the urgency aspect of your application completely, and it is also important in that ventilation that you look at prejudice for the applicant to determine whether an application is urgent or not. With regards to that, if one looks at what can maybe be expected from the applicant in this regard, and what we can deem from the papers that was filed, is that their argument with regards to this will be to say that, look, you are dealing here with a person's liberty, which in the Constitution, bar from your right to life, is one of the most important rights, is your right to liberty and freedom. And that by itself will, in our view, in my view, make the application inherently urgent.
Then let's move on to the perhaps she is successful on arguing urgency and the merits of the matter are then being ventilated. In terms of what she is alleging in her papers, it seems to be an issue around a legal deportation or a legal extradition. And she does seem to be painting a picture where she believes she was taken by South African Police Services in an area where they have no jurisdiction.
Yes. If one looks at the court papers, she actually makes the averment that she was abducted from Tanzania. Now, it is not clear from the papers whether she relies on whether there should have been a deportation or extradition. She focuses more on the extradition part. But what is also interesting is one cannot find in the papers where she indicates to this court and take the court in a conference to say that I was legally there, using a legal passport from South Africa or not. So with both instances, well, if it's with regards to extradition, one would expect her at least to have cited the Minister of Justice, because it's well known that the Minister of Justice would have made a requisition and a request to Tanzania for the extradition to be done, and that's the first step of the process. What is also interesting is, with regards to both instances where you get a deportation and extradition, one would expect to cite the Minister of Justice, as I said, and as well the Minister of Home Affairs, because both of them have a vested interest. In her application, she mentions that her legal team were corresponding with the Minister of Home Affairs, and one would expect that he himself has a vested interest thus in this matter.
Let's talk about the relief that she's looking for. I find it quite peculiar that she's asking the court to set aside legal proceedings against her in the magistrate's court. Does this court actually have those powers? And of course, let's say they do set aside her arrest. She could be arrested as soon as she walks out of this courthouse.
Yes, it is quite interesting what she's asking in a notice of motion and a prayers. She's asking to be released and then the court orders to be set aside. In my view, this court has the jurisdiction to do so, but the narrative of prosecution still lies with the NPA. Now, one would expect that if this court application then succeeds, the NPA, if they deem it fit, will then have a new warrant of arrest issued, and then she can be arrested on that warrant.
And in terms of perhaps how long these kinds of processes can take, one does expect perhaps that there's going to be a lot of debate around what the judge expects in terms of the submissions that are going to be made, and would want to make a very informed decision before deciding on an application like this.
Yes. Well, if we do not know at this stage whether the application is opposed or not, but one would expect that if the application is opposed, arguments from the opposing parties will be that in the interest of justice, their version must be placed before a court, for the court to make an informed decision on what will be the correct manner and in the interest of justice to grant this application or not.
Lastly, then, we do know Home Affairs is expected to send a legal team here. Is it going to be a difficult process for them to be joined onto this matter?
Well, they just need to prove that they have a vested interest in this matter. She mentions their particulars and specifically that they were corresponding with Home Affairs. So in my view, I cannot see that the judge will not grant them to be added to this application as a respondent.
Do you foresee it being successful?
Well, that is a difficult analysis to make. One do not know what if there is opposing papers and what will they say. It will be interesting to see what the judge says about this application and whether a proper case has been made out, because there are, as we said, certain voids and vagueness in the application. But I will certainly stay to hear what that will be.
Thank you so much.
Thank you.
All right, that is Mr. Bertus Jacobs just giving us some analysis in terms of what we can expect after 10 a.m. this morning, where we are expecting that this urgent court application will be ventilated. And like the analyst has said, is we are expecting urgency to be argued first before we get to the merits of the application.
Yeah, and definitely, Slim, we definitely heard comments from, the police minister. We heard from the Home Affairs minister also iterating that Nandipha wasn't necessarily abducted. Even the High Commissioner of Tanzania yesterday at the Cradle of Humankind been recorded saying that there are merits, to believe that she hasn't been abducted, but he didn't want to comment further, saying that they will allow the courts to delve into more evidence regarding this case. So quite a high interest case with regards to this application by Dr. Nandipha Magudumana. We'll be sure to catch up with you once again, colleague, as soon as those developments do occur at the Bloemfontein High Court. This is where Silindelo Masikane is stationed, and we'll be hearing from Dr. Nandipha and her legal team this morning just after 10.